Court rise if able.
Sorry about the delay, Mr. Coppell. Entirely my fault. I got caught up on something. We can, if necessary, sit till 4:30 or some appropriate time between 4:15 and 4:30 to catch up both with that and with a few minutes you lost earlier this morning.
Thank you.
As for Ms. Patel's note, that's helpful. It remains to be seen exactly how central it is to the submissions on delay, but Mr. Hickman will have no difficulty in dealing with it, I think, insofar as it needs to be Ms. Patel or somebody gets the chance to say anything about it for the appellants, that can be in reply.
Well, can I be clear, because I will need to deal with this on behalf of Octopus as well, that my understanding, and I've discussed this with the Appellants Council, is they're not seeking any substantive decisions from your lordships at this hearing in relation to possible remedies. The only relevance is insofar as it affects delay. And that would be our
That's
position.
my understanding, but it does potentially have some relevance to that question.
Yes, it does.
Yes.
Thank you. So my first topic this afternoon, my Lord, is the standard of review, ground two of the appeal. It was put to my learned friend Mr. Beale in argument, and he agreed that by virtue of section 29 of the EU Future Relations Act, and I quote my Lord, it is as if the provisions of the TCA are part of an English statute. So, in effect, that there was in place a subsidy control statute governing the interregnum period between leaving the EU and the coming into force of the Subsidy Control Act on the 4th of January 2023. There would then, on that basis, says Mr. Beale, be a series of hard-edged statutory rules, compliance with which is to be assessed by the court as primary decision maker and not merely exercising a review jurisdiction. We say that the appellant's submission is wrong for a number of reasons. I'm going to give you 7 reasons. Firstly, the primary authority which was relied upon by the appellants for their analysis is the judgment of Lord Justice Green in the Heathrow Airport case. And we say that subsequent Supreme Court authority has shown that Lord Justice Green's analysis is not to be taken as an authoritative statement of the effect in domestic law of any particular provisions of the TCA. And that authority is in our supplementary bundle of authorities. And it's the Lipton case at tab 3.
When was this handed up?
You handed up a hard copy yesterday morning and a soft copy came into court on Monday. So it should have 4 authorities in it, 3 from us and 1 from Octopus.
I have it, yes, thank you very much.
So in Lipton and BA City Fly Limited, the Supreme Court were concerned with the effect of Brexit upon previously accrued causes of action which the Liptons had under an EU regulation which ensured compensation for various aircraft delays. The relevant section, and we don't need all of the judgment by any means, the relevant section starts on page 91 of the bundle in the bottom right, paragraph 69, headed the role of the Trade and Cooperation Agreement. And what Lord Sales and Lady Rose, with whom Lady Singh agreed, proceed to do is to analyse the judgment of Lord Justice Green in the Lipton case, not the Heathrow Airport case. But he says essentially the same thing in the Lipton case as he had said in, as he says in Heathrow Airport. And in fact, in Heathrow Airport, he footnotes the whole of the relevant section of his judgment in Lipton. And what I would ask the court to read, if I may, is from paragraph 74 and 75, and then 78 to 80, please.
Yes, thank you. Can you just give us a second? Yes, that appears to be concerned with a conflict between domestic law and the provisions of the agreement. Isn't the situation here that following Brexit, there was no subsidy control legislation in this country? And what Mr. Beale submits is, and clearly it was envisaged that we would legislate, but unfortunately we didn't get on with it. And it was envisaged that something would have to fill a gap until that happened. Is that the particular situation being considered in Lipton?
Well, there certainly are differences between the provisions considered in Lipton, the aspirational provisions on airline compensation, and our provisions, which are obligations, and I'm not saying are aspirational, are obligations. But to be clear, the appellants are saying in this case that the TCA has automatically modified domestic law. It hasn't even had the effect of amending an existing statute. It's created a whole new statute in itself dealing with subsidy control.
Well, I see that, and it is very surprising. I find it. But the consequence, if Section 29 doesn't have that effect, what was the regime for subsidy control between IP completion day and the coming into force of the 2022 Act?
Well, I'll come on to it.
Okay.
Explain. But the key message from Lipton is that this court and any other court should not accept, as authoritative from Heathrow Airport or from Lipton in the Court of Appeal, that the TCA automatically, by virtue of Section 29, modifies existing domestic law. What one has to do in my submission as a result of Lipton is to focus carefully on the wording of Section 29(1), which you have on page 92 of that report. And what it says is that domestic law has effect with such modifications as are required to implement the TCA. And we say that means that domestic law is modified to the minimum extent necessary to comply with the international law obligations of the UK under the TCA. Yes, I'm sorry, that's so far, Section 29(1), so far as such implementation is necessary to comply with international obligations. Now, in our submission, that minimal modification of domestic law so far as is necessary is achieved by the treatment of the subsidy control obligations in the TCA as public law principles which fall to be respected by the Secretary of State when exercising his statutory powers under the Energy Act 2004. In other contexts as well, but in our context, what one needs in our context, where two decisions were made under the 2004 Act, in order to do the minimum necessary to give effect, to implement the TCA, one needs to require, as a public law principle, the Secretary of State to respect the subsidy control principles in his decisions.
Okay, hang on 1 second.
Can I ask you what you mean by public law principle? What, the principle that no person should be their own judge, or a breach of natural fairness, or a hard-edged question of law? I mean, public law principles can mean a lot of different things to different people.
Yes, it is just as there is a public law principle of acting rationally or for a proper purpose, there is a public law principle of respect for the subsidy control principles in our case.
It's very unlike any other public law principle that I've ever heard of. As my lord says, the public law principles are incredibly high-level principles about effectively, I know this is very old-fashioned, look at public law, about decision-making process. That you should be fair, that you should be rational, that you should take into account relevant considerations and not take into account irrelevant considerations, and so forth. Yes. About any exercise of power. But this is a very specific regime about a very specific activity of the state, namely subsidising commercial enterprises.
Well, some public law principles, or I should say most public law principles, are concerned with process, but not all. There are substantive principles as well.
Such as?
Well, such as acting rationally. One can
well, that's the process. That's about how you take your decisions.
Well, there is an aspect of rationality which focuses on the merits of the decision, and is it a reasonable, is it a decision which a reasonable decision maker could have taken? But we say that what this minimal implementation leads us to is that the judgments to be taken by the Secretary of State under the Energy Act, his application of the subsidy control principles, his respect for the subsidy control principles, is to be treated in the same way as the other judgments which fall to be made under Section 165 and Schedule 21 of the Energy Act. So he must correctly direct himself as to the meaning of the subsidy.
Why the Energy Act? I mean, subsidy control doesn't only arise in the context of energy.
No, but in this case, my lord, it did. These
Right,
are challenges.
but I think it's important to, at this stage, to step back from the facts of this case and see how the TCA is meant to work in any subsidy control situation, whatever the industry. Because whatever principle you're putting forward as to how it should work, whatever approach you're adopting to how it should work, must be capable of being applied in any situation where the government is proposing to grant a subsidy.
Yes. Well, I can't say in every conceivable situation, but in at least the great majority of situations, a public body granting a subsidy or something that might be considered to be a subsidy will be doing it pursuant to a statutory power. That will always be the case with local authorities, for example. It will almost always be the case, if not always, with central government. So whatever the statutory power being exercised in the particular case, that power is hedged about, is constrained by our conventional public law principles, and it is also constrained by a principle of respect for the subsidy control principles. That's too many principles. But,
Can I just ask why you say any respect? Because Section 29, which you rightly told us we had to look at, says existing domestic law has effect after the relevant date, with such modifications as are required for the purposes of implementing the Trade and Cooperation Agreement. So if the Trade and Cooperation Agreement requires a result, doesn't domestic law then have that result?
yes, but the result which domestic law requires in our case is respect for the subsidy control principles, because that's what Article 366(1) says.
Well, it's a bit more than that, isn't it? I mean,
3684 of
let's just have a look at exactly what
tab 93, page 368.
Sorry, I don't want me so slow. Tab 93, yes, thank you.
Which page do you want us on?
3684.
Thank you.
The substantive provisions, the ones that actually require you to do something, well, 366 is principles.
Well, there's
366 prohibits certain sorts of subsidies.
Sorry, 366 does.
Sorry, 366. I said 366. I meant 367. Prohibits guarantees of debts or liabilities of economic actor. Various other specific provisions there. Banks and insurance companies, export subsidies. Um, 369, various specific obligations about transparency and publication, provision of information. 371, establish an independent body. Uh, 373, right of recovery. I don't know whether the footnote helps or hinders you in that respect.
Yes.
But maybe the point I'm making is that it's not, Section 29.2 does not simply require you to implement the principles. It requires you to implement a number of specific obligations.
So, well, what we can derive from Lipton, another point, is that how Section 29 operates in any particular case will depend upon the provisions of the TCA and of domestic law which are in play. Now, what are in play in this case are primarily Article 366. I know there's the restructuring subsidy argument, but is Article 366, it's respect for the principles. And it's that I'm focusing my submissions on. There are, I can address particular other provisions which don't arise in this case if you would like me to, but you are concerned, and the Divisional Court was concerned, with a ground of judicial review of a failure to respect the subsidy control principles, in particular 3661B.
Can I test it this way? 3672 is given effect to by Section 29.1, and that is an absolute prohibition on some certain types of subsidy. Does that mean we read that as if there was an English statute which said a subsidy which is of that type is prohibited?
Well, there must be a rule, whether it's a statutory rule or some other rule constraining the exercise of the statutory discretions of the Secretary of State, which operates a bit like a policy, in the sense that you've got to, as the public body, you've got to correctly direct yourself as to the meaning of the various terms. But thereafter, it is a matter of judgment for the decision maker to be assessed.
Can we even get to that? I know this is all important to you because it feeds into the standard of review. I'm at the moment just interested in the conceptual, whatever the review, what's the conceptual basis on which prior to the 2022 Act, the provisions of the TCA, in any event, the ones we're concerned with here, Chapter 3, the subsidy control provisions, are implemented in an area where there isn't any other legislation?
To which the answer in general terms is they are implemented in the least intrusive way possible.
Namely?
Within domestic law, which in the case of Article 366 is a public law obligation upon the Secretary of State to respect the subsidy control principles when exercising his discretions under the Energy Act.
Okay, well, how about my Lord's example of 3672?
Yes. So there would be a public law principle that the Secretary of State should not grant subsidies in the form of guarantees as they're stated, and the Secretary of State must correctly direct himself as to the meaning of guarantee of debts or liabilities or whatever.
But that's a very odd way of doing it. We have a perfectly explicit provision. Why isn't it simpler to say that we construe Section 29.2 as incorporating that express provision into domestic law? Very odd to say it's incorporated, but not as a law, not as a rule, but as a public law principle, like fairness or like rationality.
Absolutely, and takes its place alongside the other grounds of review of the Secretary of State's exercise of discretion under the 2004 Act.
What's the 2004 Act got to do with it?
Well, these are challenges to
Well,
the
these
Secretary's...
are, but I'm trying to understand how this works at a conceptual level. We're not always concerned with the 2004 Act.
No, you aren't, and as Lord Sales makes clear, the answer may be different in different cases. But we're concerned with the 2004 Act, and failure to respect the subsidy control principles was pleaded as a ground of judicial review.
Are we sure this has nothing to do with the 2000? Clearly, the original provisions under which Bulb was put into administration are under the 2004 Act. It may well be the case, so we haven't been taken to the 2004 Act. But the provisions under which the bulb is then sold, are those, is that the exercise of powers under the 2004 Act?
Yes.
Whose powers?
Yes. The Secretary of State's, the
administrator, surely.
The decisions which are challenged in this case are decisions of the Secretary of State under the 2004 Act.
Are they? They are. Under what particular power in the 2004 Act was he operating when he decided to grant a subsidy?
So section 165(2) and paragraph 3 of Schedule 21.
Thank you. Can we just see that?
So it's...
Sorry, this is probably all in your skeleton argument, but I had just not internalised it at all.
And it's in the Divisional Court's judgment at paragraph 160 onwards.
Yes. Well, forgive me, I hadn't realised so much turned to it.
This is just a negative point that the transaction can't be, the date can't be set unless the Secretary of State has approved the transaction.
That's right.
165(2), Secretary of State may make grants or loans. So, are the provisions of the sale agreement, they are all grants or, the subsidies which we're here concerned are all grants or loans, are they?
Well, yes is the short answer. There's a longer answer involving the fact that the Secretary of State was lending money to Bulb, which was then passing some of it on to Hiveco. But yes.
So, sorry, what you're saying is that the way, say, to take my Lord's question, 3672 would operate in an energy, in the case of an energy administration, would be as a constraint on the exercise of powers which he was exercising under the 2004 Act, and you say any other public body will be acting under some other statutory power. And the way it works is as it were as a general, not as if it's a provision of that power, but as a public law constraint on how he can exercise it.
Yes. Well, there are differences between the provisions. Article 366 speaks of the obligation to ensuring respect. The principles, Article 367 is a bit more hard-edged, but yes, in principle, that is what I say.
Yes, I see.
And I also say that, and let's make this point quickly, it's simply wrong to suggest, as it was at one point yesterday, that Section 29 creates an action for breach of statutory duty, which could be pursued in the High Court.
Well, let's not go there.
It doesn't create directly effective rights. So that's my point about the mechanism for implementation. It's a lot. the very least, a lot more complicated than my friend made out. And we say that, properly understood, one has to place respect for the subsidy control principles alongside the other public law principles which the Secretary of State was constrained by in this case.
All right, well, at least I understand what you say.
My second reason, then, as to why my learned friend's analysis is wrong, is that the TCA itself makes clear that the UK is not required to adopt any more intensive standard of review than would ordinarily be required under public law. So we go back to the TCA provisions. You've got the respect, the principles in 3661. In 372, on page 3697, you have in 1A, the party shall ensure courts or tribunals are competent to review subsidy decisions taken by a granting authority. And we say the word review is significant here. The court is not itself applying the subsidy control principles, but reviewing their application by the granting authority. And 372, paragraph 3 on the following page.
It rather depends how the word review is being used. If that was if this were a domestic statute, obviously we would expect the draftsman to have used the word review advisedly. But in a international law context, I just don't know what its connotations are.
Well, my lord, review has the same implications on the EU side, because the Commission's decisions on subsidy control are reviewed in the way that we would understand it, and subject to a form of rationality test, just as our judicial review proceeds on
I didn't know that, but if you say that, so
I'm going to show you some authority in due course. But then paragraph 3 on 3698, we say goes out of its way to make clear that the parties are not required to, and I look at the third line, to create rights of action, remedies, procedures, or widen the scope or grounds of review of decisions of their respective public authorities beyond those existing under its law on the date of entry into force of this agreement. And footnote 1, one sees that UK law for those purposes doesn't include EU law. So what were the grounds of review available under domestic law, excluding EU law, to challenge a decision of a public body, either that a deal doesn't represent a subsidy or that it confers a subsidy which is justified? What were those grounds? Well, they were standard public law grounds, including in particular rationality, and a form of rationality which reflects the complex, multifaceted decisions that fall to be taken in commercial fields.
Doesn't that depend on what the nature of the decision that's being taken is? Judicial review, certainly, one key question is whether the decision was rational, but another is whether it was lawful. And if there's a legal requirement that it be proportionate, which is one of the principles with which we're concerned here, that's not a rationality review. That's a proportionality review conducted by the court itself.
Yes, well, that's not the question which 3723 requires you to ask. What you're required to ask is what are the grounds of review which existed in UK law, excluding EU law grounds, prior to the coming into force of the TCA. They did not include...
But once you have imported as your step one, respect for principles in Article 366, one of which is that subsidies should be proportionate, doesn't respecting proportionality mean that the test to be applied in reviewing a decision which is required to be proportionate is whether the court thinks it is proportionate?
No, my lord, it doesn't. And again, with respect, my lord is asking the wrong question. The question is, what were the grounds of review which were available in UK law prior to coming into force of the TCA? Those did not include proportionality. They did include rationality, proper purposes.
But they did include lawfulness. By reference, public law requires you, obviously, to act lawfully by reference to the parameters of the power which you're granted.
Well, put it this way, then. What were the grounds of review which existed to the exercise by the Secretary of State of his powers under the Energy Act prior to the coming into force of the TCA? That's the question in this case. They were not.
Sorry to interrupt. I just asked so I don't misunderstand. If it is a public law principle, one might say, well, if he's failed to respect it, then the decision is unlawful, and it becomes hard-edged in that sense.
Well,
and that has nothing to do with the TCA or anything else like that. That's just failing to comply with the public law principle.
Well, my lord, in my submission, not. There is the Secretary of State is constrained by an obligation to respect the subsidy control principles. On what grounds can he be judicially reviewed? What are the existing pre-TCA grounds of judicial review? He can be reviewed for rationality, relevant considerations, etc. And the fact that one of the principles happens to use the word proportionate doesn't mean then that the analysis changes and there's a proportionality test. Proportionality was not a ground of review under domestic law, and it is perfectly possible and sensible to read the requirement to grant subsidies which are proportionate as subject to normal public law review principles. Rationality, proper purpose, etc. So one really does have to ask what would have been the grounds of review against the Secretary of State's decision to grant subsidy in these in this case, prior to the coming into force of the TCA as a matter of our domestic law.
Lawfulness,
Well,
rationality.
well, lawfulness, there are certain provisions of the Energy Act where he needs to correctly direct himself as to meaning, yes. But they are well, my lord, we know what the public law grounds of review were to the Secretary of State's exercise of discretion under the Energy Acts, because there were public law challenges in this case.
Yes, well, certainly. But sorry, isn't the risk of this definition you're putting forward of 3723, doesn't then that simply undermine the requirement of Article 3661 that the granting of the subsidy respects, which I interpret as meaning observes or applies, a principle of proportionality?
No, well,
because you're undermining the express requirement of proportionality in 3661B.
No, you aren't, with respect. The Secretary of State must respect the principles, must be satisfied that a subsidy is proportionate. Then the court must be able to review the Secretary of State's decision in that regard on its normal judicial review approach. And I know Mr. Beale says at times, well, judicial review, rationality review wouldn't be effective, wouldn't ensure an effective system, but that's nonsense.
I'm not worried about that.
We've been round these houses in the convention right in EU law, Wednesday review is a perfectly effective way of ensuring compliance with EU law and other obligations. And just because, as I said a moment ago, just because the provision happens to use the word proportionate, doesn't mean that one has to import then a completely different standard of review, which didn't exist in domestic law, excluding EU law prior to the TCA.
Well, yes, yeah. Well, tell me to be clear where your submission ends up. Your submission does not say that the Secretary of State is not obliged to reach a decision which he believes is proportionate in relation to about whether to grant a subsidy, but that the grounds of review by the court are limited to saying whether his assessment of proportionality is a rational one.
Yes, just as it would be now in the CAT under the Subsidy Control Act.
That's assuming what you have to prove, because this whole argument could be rerun in relation to that. What? Even after Dalston, forgive me for not being on top of all this. Even after Dalston, are there areas where there is an obligation to respect proportionality on the part of the primary decision maker, and the role of the court in any judicial review is limited to deciding whether the primary decision maker's decision on proportionality is a rational one? I thought Dalston had rather collapsed that distinction.
Well, my Lord, there aren't that many statutory provisions which have an express requirement of proportionality, against which one could test that. The convention rights are perhaps a special case in the Human Rights Act, because we have to follow what Strasbourg does. But if one had any other statute which required the Secretary of State to act in a manner which was proportionate, his exercise of the relevant power, which imports a matter of judgment, would, we say ordinarily, be subject to rationality review. Now, can I show you an authority on that? Because it is a very long-standing principle of our public law that statutory criteria which import evaluation or judgment on the part of the decision maker do not fall to be reviewed by the court against a legality standard. If there's an element of evaluation and judgment involved, it's rationality. Now, we've got the venerable case of Monopoly and Mergers Commission ex parte South Yorkshire Transport, tab 4, bundle 1. I'm sure the court will be very familiar with that, but
I'm certainly not, so sorry to be that polite. I may when I see it.
I'm sure my Lord will be when you see it. Page 64.
Thank you.
Reference made by the Secretary of State to the Monopolies and Mergers Commission, which had jurisdiction to consider the reference if it concerned a substantial part of the United Kingdom. See letter E on the first page, and the ground of challenge was that South Yorkshire, which was the area with which the reference was concerned, was not a substantial part of the United Kingdom. The passage in Lord Mustill's judgment, oft cited, begins at page 32. Page 32 in the top left-hand corner, and And between letters F and G, there's a paragraph that begins, I agree with this argument in part. Can I ask you to read that paragraph going over the page, please? Lord Panic has asked me to ask you to read A to F as well, so you can E to F. Sorry.
Yes, it's on E to F is in fact sidelined, but that's reciting the proposition of the parties.
That's the argument.
It's obviously okay. So, but if Lord Panic wants us to read the rest, we will. But
just E to F, my lord, because that's the proposition that Lord Mustill is disagreeing with.
yes, I see what you mean. Yes, I was just surprised that was the proposition that was sidelined. That's all.
It was not by us, my lord, by the appellants.
Yeah, thank you.
So where a criterion is such, a statutory rule is such that different decision makers, each acting rationally, might reach differing conclusions when applying it to the facts of a given case, public law imports a rationality standard of review and not a hard-edged, are you right or are you not? That's absolutely bog standard public law and has been for many, many years. That is the approach which applied in this country before the coming into force of the TCA. If the statute in the MMC South Yorkshire case had said the Commission needs to act proportionately, Lord Mustill would have said exactly the same thing. Different.
As you say, it may be that we are being, or insofar as we so far been seeing it differently, we're being misled by the convention case law, where proportionality is treated, for better or worse, as being something which the court has to decide. You say that has no application here.
Absolutely, and the TCA goes out of its way to make clear in the provisions I've shown you in Article 373, in the article on, 372, in Article 373 on recovery, which also refers to the standard of review under national law, goes out of its way to make clear that it's the pre-existing public law standards which apply. And my lord, if one goes back to 366, it must logically, sensibly be the same approach whether you're applying the first principle or the second principle or the third principle, even though the second principle happens to use the word proportionate. It must be the same approach.
Each of these, you would say, involves an exercise of judgment, yes, on which people could disagree.
Yes.
And for that reason, so according to what Mustill, the standard of review is when it's been reasonable. Yes.
Yes. Now the law and rationality has developed a little bit since then, but that's the principle. So that's my third reason, that even if you did regard the TCA provisions as a domestic law statute, that wouldn't mean that you just go around as a court deciding for yourselves.
So is your
whether
third
the different. Sorry, yes. That was my third proposition. My fourth proposition I put, I think, in the course of exchanges with the court, that it's just not necessary to expand upon conventional judicial review in order to ensure an effective system of subsidy control.
You're just pausing there. Your third proposition really accepts that although your first two propositions are helpful, they don't really matter. You say even if it worked as Mr. Beale says it works, there's no reason to believe, particularly when you look at 3723, 3732, whichever it is, that from the point of view of the court, the reviewing body, it operates any differently from common law rules, right?
Yes.
Sorry, if I'm being slow, I'm just trying to follow it through.
And I think I just referred, and my Leonard Junior's asked me to draw your attention to 373 on 3699, where you've got 3732B.
Yes.
Where the remedy of recovery may be ordered where the grantor of a subsidy has failed to apply the principles or applied them in a manner which falls below the standard of review applicable in that party's law.
What do you say about the introductory part of 2, which is recovery may be ordered if a court, so that makes the court the decision maker, makes a finding of material error of law in that the grantor failed to apply the principles? I mean, that does look more like the proposition I was putting it to you, which is that a ground of review is error of law.
No, my lord, with respect, what B says, I'm sorry, what 2B says is that the granting authority can err either in not applying the principles at all, that's one thing, or applying them, which is our case, in a manner which falls below the standard of review applicable in that party's law. So if the Secretary of State had applied the principles in a way which fell below the common law as it was prior to the TCA, and yes, there's further reference to the standard of review of the national law in footnote 1. So,
can I just, while we're on 373, really, I'm afraid, going back to your first proposition, in the interim before the coming into force of the 2022 Act, which I understand it does provide for a remedy of recovery, how was Article 3731 implemented? By what mechanism? Another principle of public law?
well, it would have to be implemented by public law style remedies.
But there are no public law style remedies for recovery. That's why, as the footnote acknowledges. I'm just trying to see. It comes back to this quite difficult question of how Article 2192 was meant to operate. Sorry, 29.2 was meant to operate. Start one more time. Section 29 was meant to operate to implement the provisions of the TCA in the absence of any current law. And you've produced something which I'm going to have to think about how it works in terms of respect for the principles. But here you've got a hard-edged obligation to create a remedy not otherwise known to English law. How does that work?
Well, so what we would be talking about here is compelling Octopus to disgorge the benefit of the subsidy that they have supposedly received. And of course, the court has powers of mandatory relief.
Powers of what, sorry?
Powers to order mandatory relief, mandatory injunctive relief.
I see. So it would come under section whatever it is of the Courts Act.
Yeah, of the Senior Courts Act.
Okay.
So I don't think anybody on this side of the court is saying that there just isn't a remedy of recovery which could be ordered in this case. I don't think they are. But it would something that would have to be fashioned out of the court's existing powers.
Why isn't it just added to them? To comply with the TCA under Section 29 and its implementation by Section 29, it means we now have a remedy.
Or we would say the court could say, I do have a power in principle to make Octopus do X. I'm going to exercise it because that's what the TCA requires in this particular context.
But isn't that? I see.
That's the minimum. I'm sorry, that's the minimum, the least intrusive way of implementing.
So I think this is consistent with your previous submissions. But let me be clear about this. Are you saying that with taking 373 as a test case of a hard-edged obligation to create a right which does not exist in domestic law, then in those circumstances, Section 29 may, perhaps even will, be a sufficient basis to create a new remedy in English law without any separate legislation. But you say different obligations of the TCA fall to be given effect to or implemented in different ways, and the fact that may be the answer for 373 does not mean it's the answer for the kinds of decision we're concerned with here.
Yes, Lord, subject to the point I've just made to my Lord Justice Zacaroli, that one wouldn't necessarily need a brand new remedy because the court has existing powers.
I'm not aware of any existing powers. I mean, I think this would be a brand new remedy. The draftsperson of the TCA certainly thought it was a brand new remedy. It's not restitution, which if it is, you could say it's a whole new area of restitution.
Well, there's a danger of getting caught up as to what is a brand new remedy, what is exercising an existing power in a brand new way.
Right.
I'm happy with my Lord's formulation that we're concerned with Article 366.
Yes, I see.
Different obligations to be implemented in different ways, each of which corresponds to the minimum necessary.
While I'm interrupting you, can I just make one other point clear in my own head? TCA is a huge it's a huge treaty with all sorts of obligations in it. We've only looked at Chapter 3, which is itself a chapter of some bigger part. I don't actually think for this we've been given have we been given the title? I don't know what else is in the TCA. I now know it has something about airlines, which I wouldn't have known but for reading Lipton. But there's presumably hundreds of other. Well, there are obviously hundreds of other provisions.
It's a pact. Document. I mean, would you like?
We not? I assumed I would have got that with what I asked for the day before the hearing, but I don't. Because I'm being slow. Presumably a title and contents page for the TCA, but we haven't got it.
There probably is, my lord.
There must be. I think. Could we have it?
Yes.
Thank you.
Right. We think there's a title page, but perhaps no contents page.
Well, there must be a content. You'd think there'd be a contents page. Oh, right.
Stratford
Well,
will have read it from cover to cover, unlike me. And we'll
I mean, it's the point you're making, and Lipton demonstrates this. The point you're making in your first point is a very general point about how the TCA works. I guess, though I don't know, that this is not the only area in which there was no regulation. It was all done by EU regulation or EU legislation.
Yes, although quite a lot of the EU regulation was retained.
Exactly, but not here.
Not this.
Okay.
So, well, can I just? Well, it's 3:05. I'll go for a few more minutes and then give the transcriber a break. And I'm going to take these next points a little bit more quickly.
I'm sorry, I am very conscious we've slowed you down, but this is actually a very fundamental part of your submission, so I'm not really apologetic.
Well, my lord, it is absolutely important for the court to be clear about the mechanism of implementation.
I find it very helpful. Yeah.
It doesn't make a jot of difference.
Well, you were on 7 points. We got as far as third before I took you back to the first two. What was the fourth?
The fourth was that it's not necessary to expand upon conventional judicial review to have an effective system.
And as you say, there's lots of cases. What's your best case on that?
So in the EU context, our best case is in the supplementary bundle of authorities, tab 2, Friends of the Earth, paragraph 15 and 143 to 145.
What give the references again? 15 and
143 to 145.
Right.
So 15, you see the ground of challenge, and 143 to 145.
Where's the case?
It's in the supplementary bundle at tab 2, and the point being, in a nutshell, that Wednesbury review was effective to ensure compliance with the environmental impact directive that was at issue in that case. One also, of course, went around these particular houses with the Human Rights Act and whether judicial review was effective.
Yes, well, that's where I'm familiar with it from, but as you say, the EU context is better.
Lord, I'm afraid I don't have time to go into the authority.
No, as long as we got the reference. But that's your best case, you say, for this?
Yes.
Yeah, okay.
Point 5, the primary source of law for interpreting the TCA is not EU law, but it's World Trade Organization law. We've given you the reference in paragraph 13.5 of our skeleton argument. We've given you the reference to a finding of Mr. Justice Foxton to that effect in the British sugar case. And the WTO approach, the standard of review under WTO law, corresponds to our conventional rationality approach, whereby the reviewing body asks itself, could the evidence have reasonably supported the conclusion reached by the state? And again, I'll give you a reference to that. It's a case that's footnoted in paragraph 13.5. It's the first case in footnote 4, the Drams case, and it's bundle 6, tab 82, beginning at 2694, and I want 183 on page 3042 and 187 to 188 on page 3043.
Can I just ask one thing about that? I think Mr. Beale made a point that although there is indeed some WTO parentage in this, most of the provisions of the TCA, certainly in this part, reflect what the previous EU law was.
Yes.
And that's in a sense what one would expect purposively, because it is to retain post-Brexit subsidy control schemes that applied before Brexit.
No,
you don't accept that analysis?
No, I don't. And I would encourage you, and indeed Mr. Beale, to read Mr. Justice Foxton's ruling on this point at paragraph 54
in British Sugar.
In British Sugar. So the objective was not to retain the EU law regime, but to create a new regime, which, see Mr. Justice Foxton, is substantially based on WTO subsidy control rules and not on EU law. That's not to say that EU law is of no relevance in the interpretation of the subsidy control provisions, but the primary source is WTO.
Thank you. That's your point 5.
I'm going to give the transcriber a break before I go to my point 6, if that suits my lord, or would you like me to get to the end of this section?
All right. Yeah, thank you.
All rise, table.
5 minutes.
You don't have to. But the Divisional Court said in this case that I think I should have referred to on this first page was the objective to retain it, but I'll go back to it.
Well, you went in favour or you against? Yeah. I think it was. There is. And it's also WTO. It's in the agreement on something. It's in the agreement on it's one of the provisions. And none of that comes with the agreement. It doesn't have a clearance.
I think
You know, coming
Yeah.
Singh uses the term, both terms.
The other one well,
users weight. Margin of discretion appears in 13.
Yeah.
Well, in 14 as well. 14 is
DC in our case.
Yeah, and the obligation on the SCA it must not be well, it's not you.
Is the court ready? Yeah. Court rise in favour.
Yes.
Thank you, Lord. I was during the short adjournment, I was reminded by Lord Panic that I should have shown you, in response to your last question, Article 4.2 of the TCA. So if one goes back to the TCA provisions in tab 93, bundle 8, page 3675. Article 4.1 is TCA to be interpreted in accordance with the Vienna Convention on the Law of Treaties. And then 2, for greater certainty, neither this agreement nor any supplementing agreement establishes an obligation to interpret their provisions in accordance with the domestic law of either party. So the UK...
Well, puzzling. What's that mean?
Well, no obligation in our context upon the UK to interpret the provisions of the TCA in accordance with EU law.
I see.
And vice versa, but for our purposes, that's the point. That's relevant to the point you put to me, that the purpose of the subsidy control provisions was to retain an EU law-based system.
Well, yes, but that leaves out any arcane rules of, as you say, either party, but the ordinary Vienna Convention obligations, which is the actual obligation for, is context in light of the object and purpose of the agreement. And I haven't done as many Vienna Convention cases as you no doubt have, or as Lord Panic no doubt has, but that's not that different from what we do domestically generally anyway. Anyway.
Well,
anyway, I can see it's relevant.
So my next, I think, 6th point was was this, that it was very well established prior to Brexit that the courts, that's our domestic courts, would adopt a rationality standard when ruling on the very issue which arises in this case under Article 363. That issue being whether there was the conferral of an economic advantage on Octopus.
Sorry, Article 363, did you say?
Yes, 363 1B Roman 3.
Thank you.
Economic advantage, which requires one to ask whether a transaction was entered into on market or commercial market operator terms. That's paragraph 13.4 of our skeleton argument, and the Sky Blue case that my learned friend Mr. Beale took you to last thing yesterday. Can I ask you to turn that up? Authorities Bundle 4, tab 31, at page 1185. Oh, I'm sorry, volume 3. Yes, 3, sorry.
Oh, sorry, bundle
No,
3.
it's my fault. Volume 3.
Tab.
Tab 31.
Thank you.
As my learned friend Mr. Beale explained yesterday evening, this case concerned whether a loan given by Coventry City Council to the operating company of the Ricoh Stadium constituted state aid. If it did constitute state aid, then see paragraph 11, it was unlawful. It was an unlawful loan because it hadn't been notified to the Commission. So the key issue then in turn was whether the loan had been granted on market terms, whether the Council had been acting as a commercial market operator. Paragraph 13 on page 1189 Lord Justice Tomlinson, with whom the other two judges agreed, saying it follows that the appellants have a difficult task to the extent that they seek to persuade us that both the counsel and the judge exceeded the respective generous margin of judgment or appreciation afforded to them. That's a reference in the case of the counsel to paragraph 11, where Lord Justice Tomlinson notes towards the top of the page that the first instance judge Hickenbottom J directs himself correctly to the effect that the local authority is pursuant to the European learning afforded a wide margin of judgment when making an entrepreneurial investment decision. And then the generous margin of judgment or appreciation that the judge, the first instance court, is afforded is paragraph 12, which I think Mr. Beale read you part of, not necessarily the part that I'd rely on, which appears just before the italicised case names. We should proceed with great caution, only interfere with judges' evaluation if it falls outside the bounds of reasonable decision making. Now, the judge, as Lord Justice Thompson goes on to explain, the first instance judge had set out various uncontroversial principles. It starts at paragraph 16 on 1190, and I'm in particular concerned with principle Roman 10 on 1193 on the CMO test. And can I just ask you to read Roman 10 in the middle of 1193, please?
Yeah.
So you'll recall, my lord, that I mentioned this morning in response to a question you had regarding my summary of our position that in the case of the CMO test, the rationality standard is built into the test, as it were. Is this something which a rational market operator might have done?
Can I just ask, I mean, you accept it's an objective test? As in 10?
So under the EU law
Yeah.
approach which is being applied here, it was an objective test.
And for our purposes, objective as well?
I'm sorry, for our purposes.
When we're applying the test or the equivalent test that you're urging us to adopt, it's an objective test?
Well,
Or not?
the CMO test is an objective test, but with a rationality component built into it, and that's amounts to much the same thing conceptually.
Thank you.
And at paragraph 23, Lord Justice Tomlinson quotes paragraph 132 of the judge's judgment where he applied that rationality-based test. And he says in the second sentence, I simply cannot say that the loan extended by the council to ACL would not have been entered into on the terms in fact agreed by any rational private market operator in the circumstances of this case. In my judgment, the transaction fell within the wide ambit extended to public authorities in this area, and clearly so, it wasn't state aid. And then the only question on the appeal is whether that assessment was vitiated by demonstrably wrong findings of primary fact, or if not, whether it in turn fell outside the generous ambit of reasonable decision-making. And the Court of Appeal goes on to find, to uphold the first instance judgment. And I simply draw your attention to paragraphs 25 to 27, where Lord Justice Tomlinson explains where the rationality-based test comes from. And the very end of paragraph 27 on 1198, the test is rather whether he could have been prompted to do it, because it's only when such conduct can be entirely ruled out as inconceivable that the only remaining plausible explanation for the provision of the public funds is that it must be regarded as state aid. So that's the punchline, as it were, of the wide margin of discretion on the CMO principle. And in paragraph 63 on page 1210, the first instance judge's conclusions are upheld. Now we say that the authorities on the CMO principle, which is relevant to economic advantage, whether domestic, Sky Blue, whether Court of Justice, whether WTO, speak with one voice, that the reviewing court should apply a test of whether the transaction should be considered to be rational from an economic, commercial, financial perspective. Now, whatever the position on proportionality and proportionate in 366(1)(b, we say it's clear beyond doubt that a rationality standard is applicable when applying the criterion of economic advantage in 363.1.b.2. And my seventh reason as to why my learned friend's hard-edged analysis is incorrect is that it is well established that the EU courts adopt a rationality type standard when reviewing the decisions of EU institutions. And for that purpose, I'd simply refer you to paragraph 241 of the Divisional Court's judgment applying the Lumsden case. And they refer to paragraph 40 of Lumsden, which, just for your note, is at Authorities Bundle 3, tab 29, page 1151.
Do you want to go to that?
No, my lord, I simply rely on what the Divisional Court said in that paragraph.
I mean, the whole of that, because obviously Mr. Beale took us to it for the sort of fifth and sixth lines, which is important to acknowledge that the Supreme Court affirmed it's for the court to decide whether the decision is disproportionate. Nevertheless, the consequence is that we don't substitute our own decision. Do you say that's what the approach we apply?
Well, if you were applying a proportionality standard, which is what the Divisional Court had concluded you ought to do, my point at this stage is that's the wrong standard. It's a rationality standard, and as part of my support for that argument, I say this is what the European courts would do: would apply a rationality standard to a decision of the Commission on state aid and related.
Well, they'd be making the decision themselves, but giving a respect, deference, margin of appreciation, call it what you will, to the decision maker.
Well, they apply a test of manifest error of assessment, which is akin to a rationality test. See paragraph 40 of Lumsden. But Lord, we're now, I think, on my fallback submission, which I'm coming on to, which is if you aren't persuaded that the TCA provisions should be treated effectively in the same way as a domestic statute, even though they aren't a domestic statute, but treated in the same way as domestic rules which require evaluation or judgment, if you're not persuaded by that, and that it's a rationality type approach, then my fallback position is the Divisional Court was right to apply a proportionality type standard, but with what they referred to as a light touch or low intensity standard of review.
That's a muddled formulation, isn't it? The concept of low intensity and light touch is appropriate where you're applying a review standard. Where you're applying a proportionality standard, I don't see how there can be such a thing as light touch. I don't see how you get into it.
Well, Lord, in my submission, all of these different these are all different ways of putting the same point.
Yeah.
It's affording respect, weight to the decision of the decision maker. It's affording a margin of judgment or discretion. It's low intensity. It's all.
Well, you'd be content if we recorded that submission as being with considerable weight being given to the view of the primary decision maker.
Yes, that's what it amounts to.
Can I just be clear, what world are we in now? Is this a hard-edged decision on this fallback scenario? Because the appellant's case is this a hard-edged question, and yet they recognise you've got to give some weight to the decision. Well, you're not accepting that, I think.
No,
What are you saying here?
I'm not, and my lord, with respect, identified to Mr. Beale a serious problem with their argument, is it really proves too much. And so he retreated somewhat and said, well, a hard-edged rule with a bit of a margin. We say it's as our fallback, it's a conventional proportionality analysis, as in Dalston projects. A5, Authorities Bundle 5.
Can we just look at that again?
Yes, tab 68.
Page number? Sorry.
Begins at 2539, sorry.
Thank you.
And it's the section from paragraph 11 on 2546. And in this section, Lord Justice Singh explains that the court is not properly described as the primary decision maker. It's paragraph 19. Paragraph 19 at letter G, as Lord Bingham has said in Huang and Lord Sumption in Carlisle, the court never has that role, never has the primary decision-making role, because its function is still one of reviewing the decision of the public authority concerned. And then where one finds the analysis on affording respect and weight or a margin of judgment, etc., is paragraph 14 on 2547. And how wide is the margin of judgment? How intense is the intensity of review? These are all phrases from the case law. Depends upon the context.
Would you mind reading 20?
Mr. Beale wants me to read 20, where, well, so ask you to read 20. So I'll ask you to read 20.
Context here is asking whether the interference with the right is proportionate, isn't that?
Yes.
How does that translate to the question here? What rights are being interfered with here that one's asking about proportionality?
Well, there aren't any rights that are interfered with here. Mr. Beale sought to submit, I think, sought to raise an unpleaded claim not mentioned before the Divisional Court. His clients had a right to operate in a market without state interference, or a right to trade, or something to that effect. There are no such rights, and no such rights have been relied upon in these proceedings.
Does that matter if there are interests? So clearly the concept of proportionality we're referred to is the interests on the one hand of free, fully competitive market. On the other hand, the public interest, which requires a degree of subsidy.
Yes, one can perfectly well apply proportionality in a context where rights as such aren't an issue. You look at the objective.
Does that make a difference? Proportionality is a concept of course, I know it's a term that has many components in it, but for present purposes, it's a balance between competing interests. And in the Article 8 context, it's the balance between a right and the public interest, represented by the Act of the State Authority. And here it's a different balance, but again, between two competing interests, one of the state, one of the market participants.
Well, it's do the ends justify the means? Do the means adopted go further than is necessary to meet the objective? One doesn't need to conceptualise it in terms of the rights or interests of British Gas. One can apply a proportionality standard if one has to. But I was simply answering my Lord.
Yes, sorry, I was just following the
question.
Yep.
This isn't a rights case, but if there is a proportionality standard, contrary to my primary submission, then that standard should be applied as Lord Justice Singh explains in Dalston projects. And in the particular context of this case, we say the Divisional Court correctly reasoned that considerable weight, broad margin of discretion, etc. And one sees its findings on that in 165 to 167, first of all. where the Divisional Court cited the cases of Mercury Energy and Mauritius against CT Power, which we had relied upon as establishing a broad margin of discretion in the commercial context. And 167, that submission was in part at least rejected on the basis that the Mauritius case was not directly on point, was concerned with a situation where the government was acting like any other actor in the market by negotiating a commercial contract, which isn't what was going on here. I just want to pause briefly, if I can, on the Mauritius case. Can I just ask you to turn that up, please, in bundle A4 at tab 44. And there are paragraphs that we relied on. Paragraph 45.
On page?
It is on page 1736.
Thank you.
And paragraph 45 on 1736 summarises the issues before the board, which were whether the Ministry of Finance or Energy had acted unlawfully, according to public law standards, in making their respective decisions to refuse to confirm that condition 15 had been satisfied and to refuse to sign the implementation agreement. And the Divisional Court's reasoning is concerned with the second of those challenges, the refusal to sign the implementation agreement. But if one looks on to 46 and 47, can I ask you to read those, please? The point being that the challenge to the Minister of Finance's decision to refuse to confirm condition 15 had been satisfied was a challenge to a regulatory decision, in fact a public law decision, that CT Power hadn't provided sufficient proof of its financial capabilities. So that wasn't a negotiation of a contract, it's a commercial context, but it's a regulatory decision, wide margin of appreciation, complex evaluative judgment. So we say the Mauritius case is good authority for the wide margin that we argue for. I also refer in the Divisional Court's judgment to 168 to 171. One doesn't need to read them at this stage. 168 to 171 and 239 to 241, all of which are reasons adopted from our submissions as to why a wide margin of appreciation or judgment was required to be applied in this case.
What was the second passage?
239 to 241.
Thank you.
Now, my lords, the Secretary of State's two decisions under challenge in this case did involve, we say, a complex evaluative assessment, taking into account expert advice received from the administrators and their advisors, Lazard. And the Divisional Court, from paragraph 77 onwards, refers in some detail to what were thousands of pages of documents prepared by the Secretary of State's Department, by the JEAs, by Lazard, reviewing the octopus bid and the alternatives to the octopus bid. 77, I'm sorry, just to read out some paragraph numbers, but there's quite a lot of it. 77, 79, 85, 88, 90, 91, 94, 95, and 99 to 102. There were a range of different factors in play discussed in these documents required to be weighed in the balance, including, of course, the potential costs of the octopus bid, but also the interests of Bulb's customers, the effects of various options on the wider energy market, the prospects of obtaining a better deal in the future. You have in the supplementary bundle only a tiny selection of the contemporaneous documents, islands in the evidence, but the Divisional Court had thousands of pages, chapter and verse. So, wide margin of discretion if you are applying a proportionality type standard. The final issue which I need to address under the head of standard of review is the submission made in part by each of my learned friends that the sales process for Bulb was required to be conducted in accordance with a standard of open, non-discriminatory and competitive, which was akin to a public law fairness standard, and so should be treated as per the judgment of the court in Balajagari as a question of law entirely for the court. Now, the history of this submission is somewhat checkered. In the Divisional Court, the appellants argued that the sales process and the Secretary of State's decisions as to the outcome of the sale process were subject to a requirement of public law fairness. That submission was rejected by the Divisional Court in paragraph 173, going through to 180. I'm sorry. It's going through to 181. The Divisional Court held no duty of common law fairness owed to bidders and potential bidders in an M&A process such as this. And then the second argument which the appellant ran, which you see in paragraph 178, is that there had been a launder direction, a self-direction by the Secretary of State that there had been an open, non-discriminatory, competitive tender process, and therefore the court was required to hold the Secretary of State to that standard, as it were. And that too was rejected on the facts, primarily. 181. Can I ask you to read 181, please?
Yes.
So, self-direction point rejected, and then Mr. Beale made the submissions on the National Lottery case that you heard some of yesterday, again rejected by the Divisional Court, and none of these findings have been appealed. One might be surprised to know, given the extent to which they were repackaged and re-ran yesterday afternoon. now it seems that this public law duty of fairness is put forward as a requirement of the TCA. And at paragraph 247, the Divisional Court, we say, correctly analysed the role of the open, non-discriminatory and competitive bidding process for the purposes of the TCA. Now, I know Mr. Perrott showed you this paragraph this morning, but can I draw your attention to it as well? The M&A process had an essentially evidentiary purpose, which assisted the Secretary of State in satisfying himself and then in demonstrating that there was no economic advantage to Octopus and that the subsidy granted to Hiveco was proportionate. Not the only factor. I think you've been read extracts from the subsidy control assessment, which has in fact much more detailed passages on those two issues. We say that 247 is entirely correct, and that the appellants have been able to show the court no authority whatsoever for the proposition which is now at the heart of their case, which is that on the two issues identified by the Divisional Court in 247, Roman 1 and Roman 2, that there is an absolute requirement under the TCA to conduct a process which is open, non-discriminatory and competitive. They failed to show any authority to that effect before the Divisional Court, and their position is no better before this court.
Under the TCA?
Under the TCA.
But hardly surprising. I mean, there's not been many cases on the TCA.
Well, their argument was TCA to be interpreted in accordance with EU law. Well, where's the EU law requirement for this? What's the authority for that? And there is precious little. Where one starts on that question is with the point that there are public procurement rules derived from EU law. We have them still in domestic regulations, which require public bodies to conduct regulated tender procedures when they are purchasing goods or services. And there was some argument before the Divisional Court that the Secretary of State was required to ensure that a process analogous to the public procurement rules was followed. Rejected by the Divisional Court. The Secretary of State here was, of course, not purchasing goods or services, and the public procurement rules didn't apply. There is no rule under the World Trade Organization order that requires an open, non-discriminatory and competitive tender procedure before the state is able to say no economic advantage or proportionate subsidy. We've cited some authority in paragraph 37(1) of our skeleton argument, which I won't go to, but can I just ask you to bear that authority in mind? It's a WTO authority on the breadth of different ways in which a state can demonstrate that they have, in that case, obtained a market price. there is no such rule under EU state aid law. The Divisional Court cited in paragraph 249 the same European Commission notice that my learned friend Mr. Peretz referred you to this morning, and we say they analysed it entirely correctly. The paragraphs of the notice on which my learned friend relied, and they're at bundle 8, page 4102, tab 107. Page 4102. And they are to the effect, see paragraph 89, if the sale and purchase of assets, goods and services or other comparable transactions are carried out following a competitive, transparent, non-discriminatory, unconditional tender procedure in line with the principles on public procurement, then it can be presumed that those transactions are in line with market conditions, provided all of the subsequent conditions are satisfied. But it is an astonishing logical leap to proceed from there to submit, as my learned friend submitted, that you cannot show market conditions unless you conduct a tender process in accordance with the public procurement rules. And the notice is entirely clear that there are other means by which this may be done. And what we had in this case was, yes, an M&A process, bids received, negotiations, etc. And then we had, as I put to Justice Zacaroli this morning, we had a number of cross-checks as to the outcome of that bidding process through benchmarking, counterfactual, Ernst & Young, and so forth. So you have absolutely no authority to show you that that was wrong, and that unless we had conducted a public procurement type tender process, we simply cannot satisfy the CMO test or show proportionality. My Lord, we have put before the court in our supplementary bundle a more recent CJEU authority which supports the analysis of the Divisional Court, based as it is on the 2016 notice and the 2013 CJEU decision, and that is the Volatia case, apologies for pronunciation, at tab 4 of the supplementary bundle. And what had happened here, if you look at page 152 in the bottom right-hand corner, in the AG's opinion, paragraphs 1 to 4, you'll see the shape of the facts. A Denning-esque opinion. And in fact, 5, the AG points out that the elephant in the room is the applicability of the market economy operator test, or the CMO test as we call it. Now, what had happened was that the regional authorities had given money to privately owned airports, who in turn passed it on to airlines to encourage them to fly more to Sardinia, to pay for those lovely adverts of crystal blue waters, to encourage people to come. And on page 187, in the bottom right-hand corner, you have some discussion of the market economy operator principle by the Court of Justice. It begins at 113. And at 114, the court says, in particular, the Commission must assess whether at the time the transaction by which the advantage was conferred could be considered rational from an economic, commercial and financial perspective, etc. A test that we saw in the Sky Blue case. And then going over the page to 126, can I ask you, and I'm sorry it's a long passage, but it's just to cast your eye over the sidelined paragraphs from 126 to 132.
Yes.
And it's really, in a nutshell, it's 128. The holding of a tender procedure cannot constitute the sole method of ruling out the existence of an advantage. In particular, where the state doesn't itself carry out the sale or acquisition to or from private undertakings, but do so through an intermediary of private undertakings that aren't required to make use of that procedure. And then 132 makes the same sort of point. And where it has resonance with our case is of course, the JEAs were private sector operators who weren't required to follow the public procurement rules, had their own duties to discharge, and designed, with oversight from my clients, designed an M&A process so as to give effect to their obligations. Simply wrong to say that absent an open, non-discriminatory and competitive tender process, the TCA requires the conclusion that there was state aid or that any aid granted was disproportionate. Mr. Peretz also took you to guidance issued by Bayes on the Subsidy Control Act, which the appellants acknowledge was not in force at the relevant time, but we say is all of a piece with the EU jurisprudence. If you have conducted a tender procedure to purchase goods or services, well, that's a good way of demonstrating that there is no subsidy, but there are other ways to do it. So that's standard of review, where one gets to is essentially, and albeit via a proportionality test, but essentially where the Divisional Court got to, that there isn't a hard-edged question akin to public law fairness here. The relevant legal question is whether the Secretary of State was entitled to conclude that a rational market operator would have sold Bulb's business on the terms agreed with Octopus.
Sorry, the Secretary of State entitled to conclude that
A rational market operator would have sold Bulb's business on the terms agreed with Octopus. That's the right legal question on the issue of was there a subsidy
To Octopus.
to Octopus.
Does it make any difference as to who the recipient of the subsidy was?
Does it make a difference? Probably not. I mean, as it happens, there were two entities here who were on different corners of the deal, as it were, who felt to be treated differently according to the potential advantages which they were being granted. But had there been a different entity, or had it been Hydeco in this respect as well, we say the answer would be the same.
I think test it this way: if the Divisional Court, the Secretary of State and the Divisional Court were wrong on the question of there being no subsidy to Octopus, where would we go from there? Would the whole thing collapse and have to be redone, or would the conclusion that the subsidy, whatever it was the minimum necessary, would it still work?
Yes, it would. So my next section is findings of fact, the correct approach to findings of fact, and I hope to get to the end of this today, and that will leave me not a huge amount to do tomorrow, but if I overrun slightly on this section, it won't matter. The principles and authorities on the circumstances in which this court is entitled to interfere with factual findings of a lower court will be very familiar to my lords. I want to show you one or two of them, simply because of the extent of the departure from factual findings which the appellant's case requires you to effect if it is to be successful. I'd like to take you first of all to the authority that I don't want to pronounce at bundle A2, tab 23.
it's very craven of you. See whether you're justified. Oh yes, I've often wondered how you pronounce this.
Actually, I do know how it's pronounced. It's
Well, tell us.
Fire.
Fire. Okay, no, very well done.
I know that because it's written on the side of the carton.
It is, but it doesn't help you pronounce it.
No. The pronunciation.
Oh, is it?
On the side of the carton.
Fire. Right. Thank you.
So,
You could always cheat and call it Chobani, but
and this is Lord Justice Lewison, and at 798, we don't really need the facts, 798, paragraph 1. You see the facts in Lord Justice Kitchen's judgment, what the case was about Greek yogurt. And I need paragraph 114 on page 827. And it's really just the first 4 lines. for now, because when my learned friend Mr. Beale did pause to consider, or was forced to pause to consider, what the Divisional Court had actually found in relation to his client's accounts of the facts, he often resorted to the point, well, this wasn't a pure finding of fact, it was a matter of factual evaluation or inference. But as Lord Justice Lewison points out, there is no difference for these purposes. And the reasons for the approach, again, I'm sure will be well familiar to my lords, are set out on the following page. There are 6 numbered reasons. Can I just ask you to cast your eye over those, please?
Sorry, where are we going there?
So just over the page, the reasons for the
As you said, this is a very familiar passage.
Yes, it is.
Pleasure occasionally to refer to the actual case, but do we really need to read?
So let's move on. The reasons why the circumstances in which the appellate courts are compelled to interfere with findings of fact or evaluation of facts and so forth were then summarised by Lord Reed in Henderson and Foxworth, which is, I believe, in the following tab 24. And at 862, you have the sidelined passage ending in para 67, an appellate court will interfere with findings of fact only if it's satisfied that the trial judge's decision cannot reasonably be explained or justified. And you have at para 57, going back a few pages, at the end of para 57, an appellate court could set aside a judgment on the basis that the judge failed to give the evidence balance consideration only if the judge's conclusion was rationally insupportable. Now, the other aspect of this case law that I rely on is the point that it really makes no material difference that the lower court has proceeded on the basis of written evidence as opposed to hearing live witnesses. And can I then just give you 2 references on that point? Z and Hackney in the Supreme Court, A4, Bundle Authorities 4, tab 51. Page 1937, and there is a passage from Lord Justice Lewison's judgment in the Court of Appeal cited by Lord Sales, which includes at page 1938 at letter E the proposition that an appeal court should be reluctant to interfere with the lower court's findings of fact, even where those findings are based on written rather than oral evidence. Supreme Court and American authority cited for that. The first instance trial should be seen as the main event rather than a tryout on the road. That's one case, and the other case is the SMEC case, tab 30, in Authorities Bundle 3. I'm sorry, my lord. I should have said in Z and Hackney, Lord Sales goes on explicitly to approve those paragraphs from Lord Justice Lewison at paragraph 74. And then in the SMEC case, again, Lord Justice Sales.
Which tab did you say?
Tab 30 in Authorities Bundle 3. And at page 1180, Lord Justice Sales in paragraphs 29 to 30 gives his explanation as to why proper respect should be afforded to assessments, to factual assessments made on the basis of written evidence. And he notes in particular at paragraph 30 that the weight to be accorded to the considered view of a judge at first instance may also be enhanced where the judge has a particular expertise in the area in question, or where the judge has had a fuller opportunity at the hearing before her to go into the case and understand it in the round than this court might be able to achieve at the hearing of an appeal. Both factors apply here. Now, in our case, my lords, the hearing before the Divisional Court was exceptional as judicial reviews go. And you see that explained at paragraph 20 of the Divisional Court's judgment. Where they explain that there'd been a very substantial degree of disclosure. The chronological bundles for the hearing ran to 8 double-sided volumes. So far as the documentary record in the case is concerned, the comprehensiveness of the evidence on the defendants and interested party side would not have been out of place in a commercial court trial. So this wasn't just any old judicial review finding facts. The composition of the Divisional Court was well suited to the task of factual analysis in this case, including, as it did, Mr. Justice Foxton, an expert commercial judge with long experience of the sort of negotiations and transactions which were at issue in this case. And then still on paragraph 20, the Divisional Court had a full opportunity to hear argument about the factual issues. Extensive written and oral submissions from both sides as to what conclusions should be drawn from the material. And the output of that exceptional judicial review hearing was, we submit, an extremely detailed and impressive account of the facts, which would not be out of place in a judgment following a commercial court trial. It runs to 100 paragraphs across 32 pages with a detailed analysis of each of the areas where the parties had placed the most focus in argument, including, in particular, the matters that you've heard about from the appellants on the communication of information regarding the availability of government support, the Quantoc email you've seen a couple of times, and the issue of whether or not the appellants were in any event interested in purchasing Bulb's business. So we would say that this is a paradigm case for the appeal court giving maximum respect to findings of fact based on written materials. And it is somewhat unreal for the appellants to expect this court to overturn the ruling of the Divisional Court, very largely driven by its factual findings, on the basis of snippets from the thousands of pages of documents which the Divisional Court considered, like the Quantock email. How do the appellants deal with this problem? Well, their approach orally seemed to be simply to make submissions on the basis of their version of the facts without acknowledging that their version of the facts was squarely rejected by the Divisional Court, or that very detailed findings were made about the very documents which you were being asked then to read and reinterpret. Now, they were stopped at various points by the court, but much of it went understandably unchallenged. The most striking example, perhaps, was this morning when my learned friend submitted, Mr. Beale submitted, that British Gas pulled out because they had had no assurance that government funding would be available.
I'm sorry, my lord, I have no recollection of saying British Gas pulled out because they never did. I'm sorry to correct the factual record.
Well, I was also surprised to hear that submission because it was indeed British Gas's position that they hadn't pulled out, but we'll get the transcript later. The Divisional Court found at paragraph 72 and 73 that, and there are findings earlier in the judgment about what British Gas understood before April 2022, but in paragraph 72 and 73, the Divisional Court goes into some detail about dealings between British Gas and Lazard, and indeed British Gas, Mr. O'Shea of British Gas, and the Secretary of State. And the Divisional Court finds that British Gas was well aware of the availability of government support. And just to give one example, in paragraph Roman 9, in paragraph 72, you were shown, I think, Mr. O'Shea's first witness statement. Subsequently, some text messages emerged which he hadn't apparently been aware of when he wrote his first statement, which recorded Lazard's telling him precisely that there were government support conversations going on about balance sheet restructuring and hedging transition.
Could you please read the next subparagraph?
Mr. Beale wants you to read subparagraph 10. And in that subparagraph, the Divisional Court finds that Ms. Kotseva was clearly referencing the possibility of restructuring and hedging, balance sheet restructuring and hedging transition support in her message, and doing so in the context known to Mr. O'Shea of press reports of the business being sold on a debt-free basis with a generous financial dowry. Mr. O'Shea's response, consistent with later communications, not to express surprise, but concern as to who the support might go to. You don't have his third witness statement in the bundles, but what he said in that statement was he didn't take Ms. Kotseva seriously because she only made that, because she didn't repeat the offer, or the assurance about government support on balance sheet restructuring and hedging transition. But in any event, the Divisional Court found, made detailed findings about what Mr. O'Shea had been told, and then in 73 about what British Gas's position actually was, which was that they were only interested in acquiring some of Bulb's customers. My then friend, Mr. Beale, submitted on multiple occasions yesterday that Octopus alone, I think he repeated today, that Octopus alone had been assured at an early stage that government support would be delivered. And I did look at the transcript of this one. Page 39, line 2, page 52, line 6, page 56, line 24, page 59, line 14. And he said that the Quantock email, supplementary bundle at 601, which I know you've seen a couple of times already, but 601, the fourth bullet point up from the bottom sorry, it's what tab is it? 38. Tab 38, I'm sorry. And it's the fourth bullet point up. All government stakeholders are lined up and agree to this timetable. I really pushed. Who is it? They reiterated government would be delivered. The Divisional Court found, paragraph 61, Roman 10, letter E, quoting that email, page 112 of the bundle for the Divisional Court's judgment, it is clear to us that the question and response was concerned with the tight timetable rather than of any wider import. So, not that government support would be delivered, but that the timetable would be delivered. Now that is an interpretation which on any view is rationally supportable and cannot be overturned on appeal. Now
is that all you have to say on this point? Just so you see the time.
I do see the time. Can I just check that I don't have anything more to... Yes, I've got a few more lines, and then I'll be finished by 4:30.
Very well.
Now the Quantock email. This may be a level of detail that I don't need to descend to. It's an email between parties who weren't my clients about a conversation to which my clients weren't privy to, which my clients weren't aware of at the time that they took the decisions under challenge. But I use it to sound a note of caution about the appellant's submissions and to urge the court to consider those submissions on the facts against the very detailed factual findings made by the Divisional Court. In fact, I've got one further point on factual findings which I'll make.
Why not make that tomorrow? But you within your...
I am, yes.
Very well. 10:30 tomorrow.
What prior to available?